G'day, I'm Stephen Page from Page Provan, and what I'm talking to you today about is property settlement. It's one of those topics that we never want to talk about because it's really ugly. Having to go through a separation is just awful. I've been there and done that, and I can tell you it's not fun. But there are ways that you can get through that process more simply, and I think the starting point is to work out what is actually involved. It's very easy to let emotion override you. After all, some of the things that your husband or wife or former partner has done will just make you so angry that you want to react. It's important at this moment to realise that anger is there and to be calm during this process, because what in fact you might do, to use the old saying, is to cut off your nose to spite your face. You may find yourself embroiled in a really ugly fight, which doesn't need to occur, and then ruin what is in fact the most important financial decision that you'll ever make. So it's really important to stay calm and collected. A property settlement, we're told by the Family Court and the Family Law Act, has a number of elements to it before we get to the final part. And they are, first, there has to be some property. This sounds pretty obvious. And there has to be a decision about whether it is just and equitable or fair for there to be a property settlement. For most people, when there is a split, it's obvious that there is an adjustment of property because some of the property is owned jointly. But for some people, they don't fall in that category. For example, they've kept property separate the entire time and they don't have children. The High Court has told us that in most cases there will be this separating out of property, but sometimes there isn't. And when doing that, it's a holistic approach. We look at first, what is the property pool? This is, what do you own? What do you owe? What do you have in superannuation? And then, are there differences in values? So often there is a dispute about what valuations there are. The second thing that is then looked at are the financial and non-financial contributions to the conservation, acquisition and maintenance of property, as well as contributions to the family. If you don't have kids, then contributions to the family are going to be pretty minimal. But if you have kids, one could imagine that could be quite substantial. The court looks at whether there have been initial contributions. So what did you have right at the beginning? And what did your ex have? And what have you got now? So we look at really 3 dates, right at the beginning, when you're separated, and now. And what did you do during that period? Did you waste money or did you contribute money? And it's not all about money, but it's a great focus about money. Property settlement is really a discretion on the part of the court. So when we look at that discretionary element, it's often very hard to say it's exactly this. You're going to get X percentage or you're going to get Y dollars. It can vary. And so it's important to be realistic and realise that there is a range. It's also important, obviously, to focus about cost, because if you're going to be blowing a lot of money in legal costs, then how much is that going to chew up of your pool? And sometimes there is a focus on percentages. Oh, I'm going to get an extra 5%, but not a focus on what that might cost in legal costs. Our aim, life enabled, life simplified, has a real meaning. It's making sure that you can get on with your life and that you're not burdened by all the problems that happen when you split up. You're able to stand up on your own 2 feet and move forward. And if you look at the actuarial life tables, let's say you're 40. And if you're a woman, you've got another 48 years of life. If you're a man, sadly, a little bit less. For the next 50 years of life, do you have enough to keep you going? So we work with colleagues who are in mortgage broking, who are in financial planning, to make sure that this most important decision that you can ever make is done right. And if the two of you reach agreement, which is always the aim, and our aim is to get you in, get you out as quickly as possible, to then make sure that the whole deal is signed off. You don't want just an informal deal, or at least it doesn't work for most people, because there might be uncertainty, there might be a claim later on, there might be extra tax or stamp duty to pay. So you just want to avoid that risk. But if we cut a deal, the two of you cut a deal and we help you cut that deal, then there are a couple of ways that we would resolve that. And usually it's done with orders by the court. No one normally goes to court in that circumstance. We do it all on the papers. So you stay at home, you don't go anywhere near a courtroom, which is great. And the other way is what's called a binding financial agreement. This is a contract where you contract out of the Family Law Act. And I know I'm going into technical stuff, but it's important to know this technical stuff so that you know where you're heading. As I said, it's an honour to help people who are separating and get on with their lives, get them to stand up on their own 2 feet and live their lives without lawyers, without their ex telling them what to do. Life enabled, life simplified.